497 for the plaintiff, my client stands going to be getting to my left.
Okay.
Hannah Winter.
Okay. Your name?
Tony.
All right. And where are we on this case?
They're here on defendant's motion, so.
Yes. All right. Go ahead.
Okay, so I've served an eviction notice. And the only time I knew about anything as far as being behind in my rent, because I just found something, was this on my door. And this. The only thing I've gotten in the mail for all of March and April. That's it.
A tense eviction hearing begins as the tenant is identified in court. She immediately references a disputed eviction notice and missing rent communication. The early confusion sets the tone, as she claims she was never properly informed about arrears. The court shifts quickly into procedural questioning, signaling a financial dispute already rooted in uncertainty and documentation gaps.
You have to forgive me. I'm on the medication in it. So the last time we were in court, I had to pay $586.75. I paid that, and they wrote it down as a check. I paid it with a money order because Hannah told me, if something bounces, you have to pay with the money order. So I did. They're saying I never paid it. So I've gone through my court rec, my bank account, and it's not in there because I paid it with money order. But they're saying there's an NSF on it. It's money order. Anyway, I also paid, I want to see it's on the 2nd. I'm sorry, hold on. 2nd of March.
The tenant details a series of missed or unrecognized payments, insisting money orders were used instead of checks. She struggles to explain discrepancies between her understanding and the landlord's ledger. Her frustration grows as she insists rent was paid, yet records show otherwise. The court begins detecting a clear conflict between claimed payments and official accounting records.
2nd of March, I paid another $1,200. I put it in the mailbox, Hannah, outside your office. Do you remember getting that?
Hold on. You can't ask.
Oh, I'm sorry.
Talk to me.
Okay. Anyway, I put that in the box. That is not reflected on this ledger that I was given.
Hey, do you show that was a money order?
I know I need a receipt, and I ran out. With
No,
that.
well,
I got two money orders with receipts. So $3,000 has been paid, and it's not reflected on here. And then I guess you read my letter.
I did.
From my doctor. I do have to move.
Pardon?
I do have to move. I have to go into senior community.
Yeah, I understand. So let's try to figure this out.
What I'm requesting is to let me leave. I can't have an eviction on my record. I won't get in. I have to leave. I have to be in a safer community. My daughter's going to move in with me.
All right. So when were you, for possession, so when were you thinking about moving?
I can get into the new facilities at White Lake the end of the month. So I was going to give 30 days, but then that would put me in the middle of May.
As the hearing deepens, the tenant presents multiple payment attempts, including a significant $1,200 deposit. However, none of it aligns with the landlord's ledger. The confusion escalates when she mentions medical issues affecting her clarity. The court now faces conflicting financial narratives, with missing receipts becoming central to the dispute's credibility.
So you're willing to move by
The end of this month.
All right.
Yeah.
Yes.
So whatever was just indicated by the defendant on the record is not what the basis of her motion was. We already have a writ that has been signed. We just have not effectuated it because the bailiff We had it scheduled for April 7th, but defendant filed a motion to stay. And, you know, Flynn versus Kernopple judge, there's no reason to extend the writ date, absence and fraud or misconduct. My client did not prevent the defendant from paying on time, did not engage in any type of misconduct or fraud. She has a copy of my ledger that I gave her to review, and I'm not really sure. I'm a little confused as to what she referenced regarding the check versus the money order, because she said that it showed on the ledger that it was paid by check, but then she said it was a money order, but then she said it wasn't reflected. So I'm not really with you, but nonetheless, the balance pursuant to the previous judgment was not paid. And so we would ask the court to.
So since the time of.
The tenant shifts focus to urgency, revealing she must move into senior housing immediately. She requests leniency, fearing eviction will block her relocation. Meanwhile, legal representatives argue over procedural justification, citing prior judgments and enforcement rights. The emotional pressure rises as personal necessity collides with strict legal enforcement timelines.
February. Well, March and April, you've not received anything?
No, that is not what I said. May I see the ledger?
Oh, sure, absolutely.
There were payments made, Your Honor, but not enough to satisfy the.
Okay, and that's what I'm trying to figure out.
Right.
How many?
So she made a payment. The judgment required her to pay by, I believe it was 27th of February.
Yes.
And by the 27th of February, she paid $1,300 and then another $585.70. And so her balance was $3,000 on the date of the expiration, the rate date.
Got it.
So after that, she's made a couple more payments, but now we're at a new balance because March rent and April rent has accrued. So we're at a balance of $3,754.50. Defendant indicated to me that she paid another payment in cash. That's impossible. Our client does not accept cash.
Right.
So we would ask the court to deny the motion to stay to allow us to reschedule the bailiff to come out and effectuate the rate, Your Honors. There's no legal basis for the extension of the writ. Although I do appreciate life happens and it's unpredictable, but then my client would be prejudiced if the writ was delayed any further.
You said the amount owed is, at this point, is $3,700.
$54.50, correct.
Plaintiff counsel challenges the tenant's version, insisting payments remain insufficient despite partial receipts. The judge begins breaking down figures, attempting to reconcile conflicting ledgers. Confusion intensifies as both sides dispute whether payments were cash, check, or electronic transfers. The financial picture grows increasingly complex and contested.
And the writ has already been signed. Any attempt at payment, my client cannot.
Pardon?
My client cannot receive any payments after it's the signing.
So I'm just trying to figure out, from the time of the judgment to today, how much do you have? Do you have that total amount?
I do, Your Honor. I have, as I indicated, she made a payment after the hearing that was the subject of the judgment. She made a $1,300 payment and then $585.70. And then the $585 was actually returned as insufficient funds. And then she made another $3,000 payment on March 6th. So she made a payment of the $3,000 plus the $1,300. So, but the $3,000 was paid subsequent to the writ date on March 6th.
Right, but she paid $3,000
She made a payment of $3,000 on March 6th, correct?
on March 6th. And I have another $1,480 that she posted that you may not have been aware of, counsel.
I am aware that she did post
Right,
pursuant to this motion that she also filed.
right, okay. So, just ballparking it, if that were released, there's about $2,000 that's owed, right?
So, can you indicate the amount again, Judge?
Pardon?
Do you want this in escrow?
In escrow, I have, just $1,480.
So that would bring her total that would be due in owing today would be $2,274.50. However, she has indicated her desire to vacate and that she has some living disability. I'm sorry, I made a mistake.
Yeah, independent.
Right.
The judge methodically calculates balances, identifying partial payments and unresolved NSF issues. The total owed is narrowed down to a precise figure. Plaintiff confirms a writ has already been signed, increasing urgency. The courtroom atmosphere tightens as legal consequences become imminent, with eviction enforcement now clearly in motion unless resolution is reached.
May I say something?
Yes.
Again, I want to correct myself. I did not pay cash. I pulled out cash and got a money order. Not reflected on the $586.75. They're saying it was a check and that it bounced. I don't have checks. I get money orders. So I don't know what they did with it.
Ma'am, so you're disputing that you owe, you're saying that you don't owe anything?
No. I do owe. Not that amount.
Okay, so, well, let me ask this. How much do you say you owe?
Is that 3? Okay. 15. I paid $2,700, including that $1,480 with it. So $2,700 has been paid, and I've got the receipt for the money orders at home. I ran out. I forgot to bring one.
You're saying you paid $1,300.
And then I brought in the $1,450 the other day, or $1,480.
So there's about 1,000, hold on. There's about 1,000 or about $1,100 difference between what you say. You admit you owe about $1,100 more.
Yes, but I don't know what happened to the 586 money order. It couldn't have bounced. It was a money order. And they charged me $25 for an NSF. That was impossible.
Dispute escalates over whether payments were properly submitted online or through physical money orders. The tenant insists she followed instructions, while attorneys argue system errors and missing transactions. A key $1,480 escrow-related amount is introduced, shifting the financial calculation again. The court now attempts to determine what funds are actually recoverable.
And I called management company on it, and they're like, "No, I don't have checks."
Your Honor, can we swear in my client because she wants to make a statement with regards to that 585? And I would like the court to take a look at the ledger and how it reflects insufficient funds. But my client has information regarding the insufficient funds and how they were received originally.
All right, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
All right, go ahead.
Okay, so on February 27, 2026, as I indicated to the court, there's an amount of $585.70 that's reflected by check that was paid, but then it says NSF. And my client, I would like to ask my client, how was that payment made on February 27, 2026?
That payment was made online through our rent processing website.
So it wasn't by money order?
It wasn't by money order or physical paper check.
Okay, and then can you indicate?
So just let me, on the online, does it really equate to an electronic check to a bank account? Is that?
You can type in your account and routing number to make a payment.
Got it. And so that's what actually came back NSF.
That's why it's abbreviated as check.
I got it.
Thank you.
Okay.
So
Escrow becomes central to the hearing as the court recalculates what remains unpaid. The tenant admits partial debt, but disputes the exact total. Attorneys attempt to reconcile figures, narrowing the gap to roughly $1,100 difference. Despite continued disagreement, both sides begin moving toward a conditional resolution framework.
It's my turn, let me know. So I could show where the day I paid the 586, my social security check had just come in that day. So I had plenty of funds in my account for that money to be withdrawn. There is absolutely no reason why it wasn't.
But
I
you
don't
have
know.
the 586 now?
Well, they never, no, they haven't.
Well, obviously they don't.
Well, that's what they're saying. So I don't know. All I know is what I did. And I took out the money because I had to pay that. I did. That's what,
So are you saying that it wasn't paid through their portal or their online payment?
no, because Hannah told me I could only use money orders to pay my rent. So again, I have the receipt at home. I can produce it. I just ran out with that.
I will know. Department Code did send her a letter indicating that, dated March 6th, indicates that the payment was returned, which is lost.
That's impossible.
What's impossible?
Here's my bank statement.
Okay, but
They never submitted it, Your Honor.
Under pressure, the tenant acknowledges she owes money but insists the amount is incorrect. She struggles financially, revealing limited monthly income. The judge emphasizes the legal reality of eviction already being signed. Emotional tension peaks as the tenant risks losing housing unless immediate payment arrangements are made.
I'm sorry.
if they never submitted it,
According to what they're saying.
pardon?
According to what they're saying.
But if they never submitted it, it was an online payment and they never submitted it, and that means you have the money.
Correct. But they charged me $25 for an NSF.
Okay, so if I take $25 off of this, you have the money?
I didn't. Well, I don't have $1,000. I have like 700 to last me till the end of the month.
Okay, so here's the problem. The problem is that even if I take off to try to get you, because you're gonna move anyway, to try to get you a little bit further in the month and say, okay, just because they're gonna have to try to chase you down for the amount anyway, because they didn't ask for a money judgment. If I said you need to at least pay the difference and maybe I'll look at extending the time, you're telling me that you can't.
Well, not 3,000 because I'm saying I don't know that much.
Okay, follow me here.
I can prove.
When there was about $1,100, right? Between what you owe, that's undisputed.
Okay, I can go with that.
So can you pay them the $1,100?
I pay them 700 today. And get the rest home next week or the week after.
It doesn't work
Before
that.
the end of the month.
Well, it doesn't work that way.
Well, Honor, I bring in $1,900 a month.
Ma'am, I understand, but I also understand that they had a judgment.
The court pushes toward resolution as escrow funds and a reduced payment plan are negotiated. A compromise emerges, $400 plus escrow release to delay eviction until April 24th. The judge warns the writ can still execute after that deadline. Final agreement is reached under strict conditions, preventing immediate eviction but leaving a narrow window for compliance. Like the video, subscribe to the channel, and we'll see you in the next video.
There's a writ that's out there. You didn't come here, and what you're asking me to do is to extend the writ or not allow the writ to go forth. And I don't want, to be absolutely honest with you, I don't want to tell them they can go ahead with the writ without giving you an opportunity to at least get yourself out. I think it saves both parties, quite frankly, a lot of aggravation to do it that way. But in order for me to even consciously do that,
Okay.
I'd have to say, well, you're disputing 1,300, basically. As my math goes, somewhere around that figure. And then this is the amount that's owed. So pay the difference. And then maybe I'll give you more time. But you can't pay the difference.
All of it, 400.
Pardon?
Pay all of it for 400.
Well, and that's part of the problem. Because it's not just 400, because then there's this other amount that I'm kind of just putting to the side that they claim is still owed.
Okay, so for the month of April, right? But they're not going to accept April payment. They don't want April's rent. She told me I can't pay it. They're trying to evict me.
I know they're trying to evict you.
Right.
I signed the order. I get that. I'm just saying they weren't going to take it. And I get that. But the thing is that you paid it into the court.
Right.
Okay, there's that money. But then there's another 1,100 basic. And then that's when I asked, can you pay the 1,100? You told me no. That 1,100 really constitutes, based upon my rough math, the difference. It sets aside what you're claiming is the disputed amount.
And again, I have my receipts at home, Your Honor.
But it wouldn't matter. I've already sort of said in this scenario I'm going through in my head, I'll just say, okay, you did that. You're still 1,100 off.